Good morning. This meeting will come to order. This is a public meeting of the Commodity Futures Trading Commission to consider issuance of a proposed order granting exemptive relief for certain requirements of the Commodities Exchange Act as amended by the Dodd-Frank Act that becomes effective on July 16, 2011. In addition, the Commission will vote to schedule future Commission meetings in July, August, and September to consider the issuance of final rulemakings under the Dodd-Frank Act. Before we hear from staff, I'd like to thank Commissioners Mike Dunn, Jill Summers, Bart Chilton, Scott O'Malley for all of their thoughtful work to implement the Dodd-Frank Act. Commissioner Chilton could not be with us today because he is speaking at the European Commission Bureau of European Policy Advisors. We do have his cell phone if we need to call him and link him in. And I do want to say, I'm going to keep doing this, Mike, but since I know that 3 days, or are we? No, we're 5 days. You keep reminding me. The 19th, we're 5 days away from Commissioner Dunn official term of office, but as we all know, he's been gracious enough to say he'll be here on the 20th and the 21st, and he'll keep coming in, I hope, and continue to serve this nation and this commission. And so we'll have ample time because the Senate has to do something before you're out of here, Mike, so we'll keep thanking you. I also want to thank the hardworking staff at the CFTC, everyone really on the many things we're doing, but particularly Dan Berkovitz, Terry Arbit, Harold Hardman, and Carlene Kim. I see Ananda is also going to be with us chatting about some things for preparing the recommendations that we'll hear today. This is a complex area, and I think that they've drafted a proposal that appropriately addresses the issues. But with all that else is going on here, I know that it's short notice, and I thank my fellow commissioners to somewhat putting up with that because it is certainly we probably all prefer to have had this 6 or 8 weeks ago, but I think they've found the right balance here. I welcome members of the public, market participants, members of the media at today's meeting, as well as welcoming those listening to the meeting on the phone and watching live webcast. The proposed order, as well as fact sheets and Q&A documents, will be posted on our website shortly. Now, I intend to support the proposed order regarding the effective dates of certain Dodd-Frank provisions. The Dodd-Frank Act has a deadline of 360 days after enactment for completion of the bulk of the rulemakings. There's some that were other dates, importantly, position limit rules, but the bulk are July 16, 2011. But both the Dodd-Frank Act and the Commodities and Exchange Act give the CFTC flexibility and authority to address issues related to effective dates of Title VII, and we've coordinated closely on the SEC on these issues. More specifically, there's a section of the Act, Section 754, that says that the provisions related to swaps in Subtitle A provide for those regulations to take effect 360 days after the date of enactment, or to the extent a provision requires a rulemaking, not less than 60 days after publication of the final rule and implementation in line with that. Thus, those provisions that require rulemaking will not go into effect until the CFTC finalizes the respective rules. And that's the substantial portion, maybe even the majority of provisions require rulemaking. And they'll only go into effect based upon the phased implementation that this Commission is still considering in terms of final rulemaking. But there are provisions of the Act that do not require rulemaking that may go into effect on July 16th. And the proposed order that we're considering today would provide relief until December 31st, 2011 on when the definitional rulemakings become effective, whichever is sooner. So there's a set of definitional rules, swap and swap dealer and so forth. Until those are finalized, other parts of the Act have some ambiguity, of course. The proposed order also addresses relief through December 31st of this year from certain Commodity and Exchange Act requirements that come from repeal of provisions. And the staff will go through those repealed provisions and how we're granting relief from that. There have been suggestions to delay implementation of the derivatives reforms included in the Dodd-Frank Act. That's really not what today's proposed order is about. Instead, it provides the time necessary for the Commission to complete its rulemaking and to continue to work with the public and our other regulators. Now, some might ask, why 6 months? 6 months will provide the Commission with the opportunity to re-examine the status of final rulemaking in light of the changed regulatory landscape at the time. It would be my hope that we can complete many of the rules within this 6 months, maybe even most of the rules in this 6 months, but there will be a changed regulatory landscape and we can reassess it at the time. And if appropriate at that time, but only if appropriate, we could tailor relief to the provisions that still were outstanding that we need to consider. It's important to note, however, that until the CFTC completes its rulemaking process and implements and enforces the rules, the public remains unprotected. The proposed order will be open for public comment as well. So if there's something that you think that we've missed, please let us know. It's going to be a short window of 14 days of public comment from the time it's in the Federal Register, which I suspect will take a few days, and that it's our hope and I believe that we will be able to finalize an order before the July 16th date. So before we hear from staff, I'd like to turn it over to Commissioner Dunn.
Well, thank you, Mr. Chairman, and thank you all for joining us today for another meeting of the Dodd-Frank Act. To date, the Commission has issued over 50 advance notices of proposed rulemaking, 2 interim final rules, 1 final rule, 1 proposed interpretive rule. This has been the most transparent rulemaking process that I've been involved with in over 20 years of rule writing. The sheer amount of information that staff has reviewed, the meetings they have had, the questions they have answered regarding Dodd-Frank could only be described as monumental. Yet staff has completed all this work while simultaneously continuing their pre-Dodd-Frank duties. The qualities of the rules have been so far in the facts that the market are regulated have continued to operate efficiently and effectively is a testament to the quality of the staff we have at the CFTC, and I thank them all for the work they've done and are continuing to do. Many have said that our agency is moving too fast to implement Dodd-Frank. They claim we have not given them enough time to comment and that we have not given ourselves enough time to fully appreciate the effects of the rules we are writing will have on the market soon to be under our jurisdiction. An equal number of individuals are claiming that we're moving much too slow with the rulemaking process. They claim that anything less than strict adherences to the congressionally imposed deadlines with Dodd-Frank is a failure. Given our level of staffing, I believe we are moving at a pace that ensures that the rules are written following the intent of Congress, are responsive to the comments of the American public, and based upon sound and fundamental market principles. If we were to move slower, I fear that unnecessary delay may leave the country vulnerable to another financial crisis. If we were to move faster, I doubt the quality of written rules would continue to remain as high level as I have become accustomed to receiving from our staff. Regarding today's meeting, once again, I think it's a testament to Chairman Gensler and the transparent nature of the process he has overseen. The staff, together with market participants and users, were able to identify issues with the July 16th date and develop an effective way to ensure that until our rules are completed, market users will continue to have the ability to effectively use derivatives as risk mitigation instruments. The proposed exemptive relief has a sunset provision of December 31st, 2011 that I strongly support. While others may argue that the market requires certainty, there is no way that we will meet this date. I believe these fears are unfounded. The sunset provision sets an ambitious but achievable goal for completion of Dodd-Frank rulemaking And I believe that the Commission and its staff should be held accountable for providing needed certainty to the markets and the public by that date. Should we not finish by December 31st, it is nonetheless appropriate and prudent to periodically review the extent and scope of relief provided from the CEA and to tailor that relief to the Dodd-Frank implementation schedule. We will know more about the full mosaic of the rules by December and that we know now, and that knowledge will help us fashion additional exemptive relief if needed. A more personal reason is that it is likely I will no longer be a commissioner by that date. I believe that my successor should have a voice in establishing the policy governing the CFTC at that time. Regardless, today's proposed order will not affect the Commission's ability to provide further relief to prevent undue disruption or cost to market participants. Again, I would like to thank the staff of the CFTC for all of their hard work on these very important proposed rules, and I look forward to their presentations.
Thank you, Commissioner Dunn. Commissioner Summers.
Thank you, Mr. Chairman. Good morning. Today we are dealing with an issue of great importance to me, providing some certainty to swap market participants concerning the status of their swaps transactions on July 16th, the general effective date of Dodd-Frank. First, let me say that I intend to vote for this relief because I believe the markets need guidance from the Commission as soon as possible, but I do so reluctantly. The legal provisions added by the CFMA in 2000 were critical to market participants, and I believe that by passing Dodd-Frank and repealing those provisions of the CFMA, Congress in no way intended to decrease the confidence in the markets. Yet that is what has happened. For months, I've been talking about the legal uncertainty that would arise on July 16th. And I've said that the Commission needed to act sooner rather than later. Market participants have said the same thing. Instead of acting sooner, we are acting later, even though we have all known for months that despite our best efforts, regulations implementing the new regulatory regime would not be finalized and effective by July 16th. As a result of waiting until the last minute, we have needlessly allowed uncertainty to mount among market participants. As an example, it has been reported to me that as a result of the uncertainty surrounding the applicability of business conduct standards for swap dealers, some swap dealers have already informed their pension fund swap counterparties that as of July 16th, they will no longer be able to act as counterparties to pension funds. DCOs are wondering if they are required to have chief compliance officers in place. This kind of ambiguity is not acceptable. I recognize that because the Commission waited so long to issue this proposal, we have no time to spare. I am optimistic that the proposal we have before us today will answer all of the pending questions and concerns regarding how agreements will be treated after July 16th. The objective should be to craft relief that is not confusing or convoluted and that clearly allows swap market participants to continue operating as they are today and have been since 2000. If that is not what we have accomplished, then I fear we will be inundated with critical comment letters, and the process of finalizing the exemptive relief will be very difficult for us to resolve in 1 month. In my view, we should utilize the grandfather relief as Congress intended by grandfathering 2H and 5D markets for 1 year and fill the remaining gaps with clear and concise 4C relief. Where 4C relief is not possible, my preference would be to issue some form of commission action rather than no action relief from staff. The current approach, along with its expiration less than 6 months after July 16th, is not ideal. If we are intent on allowing this relief to expire on December 31st, if we are not intent on allowing this relief to expire, we should commit now to a commission meeting on Tuesday, November 1st to propose whatever continuing relief is necessary so that we do not again rush to provide market certainty at the very last minute. Before I conclude, I would like to address two additional issues. First, legal uncertainty among market participants has not been limited to the issues surrounding July 16th. Legal uncertainty is mounting in the area of how the Commission views the extraterritorial application of its new authorities under Dodd-Frank. Despite many requests to clarify our view, we have said woefully little on the topic, and the questions we ask in the registration proposal, in my mind, do not answer many of the important questions. My office has been working internally to promote conducting a roundtable on extraterritoriality issues. Unfortunately, we have not set a date yet. But I'm hopeful that this will be another topic that interested parties will be willing to participate in to share views and offer us their suggestions. I believe we have an obligation to address these important issues before the Commission begins to finalize our proposals implementing Dodd-Frank. Second, as we vote today to set meeting dates over the next several months, I again ask that we establish a schedule for finalizing rules that makes sense and allows staff and the Commission to fully consider input from commenters and input from each other, and allows the Commission to fully consider the provisions of each rule before we cast our votes. I believe it is irresponsible for us to calendar 5 to 7 final rules per meeting. We need the opportunity to consider every single issue included in each rule and think about the implications very carefully. If we do not, I think we'll be doing a disservice to the critical markets and market participants and to the American public. I want to thank the team in OGC and all the Commission staff for the hard work they've put into this order today, and I look forward to the discussion.
Thank you, Commissioner Summers. Commissioner O'Malley.
Thank you, Mr. Chairman. As the other commissioners have discussed, we are here voting today to decide an issue that's been at the forefront of every market participant's mind, namely what happens to my business on July 16th. What makes the 16th so important? That is the date certain provisions of Dodd-Frank take effect. These provisions include repeal of the CEA exemptions and exclusions for transactions in exempt and excluded commodities on which many market participants currently rely. But on that date, market participants have no practical way to comply with the Dodd-Frank provisions. Specifically, the Commission has yet to issue a final rulemaking on key definitions such as swap or swap dealer. The Commission has yet to complete the regulatory framework for swap execution, including the CEF definition. Given this situation, it is understandable that the market participants have requested again and again that the Commission provide clarity and certainty that their current practices would continue to be acceptable after July 16th. This need for certainty goes beyond regulatory certainty. Market participants need to know their business activities will not expose them to increased litigation and counterparty risk as well. Today we are voting on a proposed order that is supposed to provide certainty and clarity. The proposed order intends to exempt market participants under CEA Section 4C from complying with any provision of the Dodd-Frank Act that references key definitions and from having to alter the current practices in light of the repeal of the CEA exemptions and exclusions. I support the proposal because we are just 1 month away from the July 16th deadline. It is also important that the Commission show participants that the relief that it is contemplating. I do believe that the relief offered is imperfect for the simple reason that it ends at an arbitrary date of December 31st, 2011, even if the Commission does not finalize key definitions or swap execution framework before that time. December 31st is an arbitrary endpoint. First, the Commission has not set forth a comprehensive sequencing for consideration of the final rulemaking. I'm afraid that setting an arbitrary date in the proposed order will just leave markets with the same questions that they have today. And what will we have accomplished? We will be putting form over substance for the sake of an arbitrary date. And how does this benefit the public? Second, I find that the reasons proposed in the proposed order for the arbitrary 31st date to be unconvincing. First, the proposal states it is, quote, appropriate to periodically re-examine the scope and the extent of any exemptive relief in order to ensure that the scope of the relief is appropriately tailored to the schedule of implementation, end quote. This statement seems to suggest that the Commission has two choices if the requisite rulemakings do not take effect by December 31st. One is to extend relief for a second time, or two, let the exemptive relief expire. I would suggest that the Commission only has one responsible choice: to extend the relief until the final rules are implemented, instead of focusing on an arbitrary date that creates market and legal uncertainty. Second, the proposal states that limiting exemptive relief is consistent with other provisions of Title VII. The proposal references the one-year grandfathering provisions available for persons relying on Sections 2H and 5D of the CEA. I am baffled as to how a one-year grandfathering provision supports limiting exemptive release to less than 1 year, namely 6 months, based on an arbitrary date. Finally, because the Commission has not set forth a comprehensive implementation schedule for the final rulemakings, I have a specific question as to whether, with respect to the proposed order. The proposed order builds in part on existing Part 35 of the Commission's regulations. But on February 3rd, 2011, we published a proposal in the Federal Register that would revoke Part 35. This proposal is entitled Commodity Options and Agriculture Swaps. So the proposed order tells the market participants to rely on Part 35, which we have already proposed revoking. If we were to give the market an implementation schedule, as I've suggested over and over again, things would make a little more sense. I have drafted an amendment that I will be offering to extend the relief of the proposed order until the Commission completes the relevant rulemaking and the final rulemakings become effective. This amendment would give market participants the clarity and certainty that they have requested. This amendment will also be in line with the relief contemplated by fellow market regulators such as the SEC. I'm also reiterating my call for the Commission to set forth a comprehensive schedule for the public for a public comment on both whether it plans to vote on a final rulemaking and the order for when the rulemakings will become effective. A schedule will help the Commission avoid potential contradictions like our treatment of Part 35. I hope the Commission will favorably consider my amendment and my renewed call for a rulemaking and implementation schedule with an open mind. As I have stated, even if the amendment fails, I will support the proposed order. As Teddy Roosevelt said, "You do what you can with what you have where you are." I welcome public comment on every aspect of the proposed order, especially with respect to when the Commission has provided legal certainty it needs or whether the arbitrary 31st end date promotes or undermines this certainty. Mr. Chairman, I appreciate you calling this hearing and moving this as expeditiously as we can. Thank you.
Thank you to each of the commissioners for your thoughts, and without further dispatch, Mr. Berkovitz, Mr. Hardman, Mr. Arbit, Ms. Kim, and Ananda. I didn't know you were going to be up here, but Mr. Radhakrishnan.
Thank you, Mr. Chairman. Good morning, Commissioners. First, I would like to thank all of the members of the OGC team that have worked very hard on this order. Harold Hardman, Terry Arbit, Carleen Kim, Neil Kumar, Sue McDonough, and Mark Higgins. I also would like to thank the divisions for their helpful comments and support on this project. The proposed order before you today clarifies how the Commodity Exchange Act will apply to swaps as of July 16, 2011, the general effective date of Title VII of the Dodd-Frank Act. As you noted, Section 754 of the Dodd-Frank Act provides that, unless otherwise provided, provisions of the Act that require a rulemaking are effective no sooner than the earlier of 60 days after the rulemaking is completed, or 360 days after enactment, which is July 16th. Many provisions fall into this category. Although the Commission has issued proposed rules to implement these provisions, these rulemakings will not be completed by July 16th. Examples of such provisions include the registration of swap dealers and major swap participants, margin and capital requirements for swap dealers and major swap participants, and external business conduct standards for the same. Because these provisions will not become effective until the rulemakings have been completed and implementing dates established, the proposed order does not include relief from these provisions. We have provided the Commission, and the Commission is publicly releasing on its website, a list of provisions that require a rulemaking. Provisions that do not require a rulemaking are effective on the general effective date. Thus, certain provisions of the Dodd-Frank Act will become effective immediately on July 16th, while others will be phased in over a period of time. The proposed order before the Commission would provide clarity to market participants and the public regarding which provisions of the CEA, as amended by the Dodd-Frank Act, will apply during this transition and those which will not. The draft proposed order proposes to grant exemptive relief in two parts. Part 1 of the draft order proposes to address provisions that would go into effect on July 16th, but that reference terms such as swap, swap dealer, major swap participant, or eligible contract participant that the Dodd-Frank Act requires the Commission and the Securities Exchange Commission to jointly further define. These definitional rulemakings will not be in place by July 16th. Accordingly, the draft order proposes to temporarily exempt persons or entities from complying with these provisions until the earlier of the effective date of the definitional rulemaking for such terms, or December 31st. The exemption would apply only to the extent that provisions specifically relates to entities or instruments such as swap, swap dealers, major swap participants, and eligible contract participants. Part 2 of the draft order proposes to address provisions of the Commodity Exchange Act that will or may apply to certain transactions in exempt or excluded commodities, which are primarily financial commodities, energy, and metal commodities, as a result of the repeal of various CEA exemptions and exclusions as of July 16th. Specifically, Commodity Exchange Act Sections 2D, 2E, 2G, 2H, and 5 non-paren D, as well as the so-called line of business provision that was originally provided in the swaps policy statement. Although Part 35 of the Commission's regulations is still available to provide exemptive relief upon this date, Part 35 does not cover certain of these transactions. The proposed relief would cover these additional transactions, such as those entered into by eligible contract participants, standardized transactions, cleared transactions, and transactions traded on trading facilities. The Commission is proposing to temporarily exempt such transactions until the repeal or replacement of certain of the Commission's regulations or December 31st, whichever is earlier. The proposed exemptive order would be issued under Section 712F of the Dodd-Frank Act, which specifically authorizes the Commission to issue exemptive orders in preparation for the effective date of the Dodd-Frank Act, and Section 4C of the CEA, which provides the Commission with exemptive authority for many provisions of the CEA. As required by Section 4C, if approved by the Commission, the proposed order would be subject to a period of notice and comment. The proposed order provides for a 14-day public comment period. This would provide the Commission and staff time to analyze the public comments and issue a final order as appropriate prior to the July 16 effective date. The proposed order does not provide relief from all of the provisions of the CEA that will become effective on July 16th. The staff has also provided a list of those provisions for which relief is not being provided, and this will also be on the Commission's website. Examples of such provisions include the core principles for designated contract markets, the core principles for derivatives clearing organizations, and the prohibition on certain disruptive trading practices. There are a few provisions in the CEA that will apply as of the effective date and for which the Commission does not have authority to issue exemptive relief. The staff is considering whether to issue no action relief from these provisions. Before concluding, I would also like to highlight several limitations on the scope of the proposed relief. First, the draft order does not provide relief from the Commission's anti-fraud and anti-manipulation authorities. Second, the draft order does not affect any Dodd-Frank Act implementing regulations that the Commission promulgates, including any implementation dates therein. Neither part of the proposed order would affect the Commission's authority with respect to futures contracts, options on futures, or transactions by retail customers in foreign currency or other commodities. The proposed order would not apply to any provision of Title VII of the Dodd-Frank that has already become effective. Fifth, the draft order states that the proposed relief would not limit the Commission's authority under Section 712F, which provides the Commission with authority to engage in exemptions, rulemakings, and other actions necessary to prepare for the effective dates of the provisions of Title VII. In addition, the draft proposed order would not affect the Commission's ability to provide further exemptive relief as appropriate, either prior to or after any future event. I'd be happy to answer any questions. Thank you.
Thank you, Mr. Berkovitz. Before I ask for a motion on that, I realize that I traditionally ask for unanimous consent that all final votes for proposals be taken by voice vote, recorded vote, and published in the Federal Register without objection. I would, at this time, then entertain a motion on the staff recommendation on the proposed orders.
So moved.
Second.
With that, I had just a few questions. First, we'll publish today on our website what you called Category 1, or in the proposal, Category 1 of all those things that require rulemaking. Is that correct?
That's correct.
And so the public would be able to comment on that if they think that there's ambiguity or any questions or doubts about what we've put there. Is that right?
Yes, Mr. Chairman.
Okay. And then is it correct that anything that's on that list only goes effective when the final rule happens and whatever implementation phasing that we put in there?
That's correct. Those rulemakings, there would be a minimum of 60 days before those rules could be effective, and further, the Commission would establish implementation dates for the requirements in those regulations.
Right, and we've benefited 2 public roundtables with the SEC. We've had a comment file that was open for about 60 days. The staff put out concepts. We're considering Commissioner Amalia's suggestion that we do more to get more public feedback than we've already gotten on this. But my question then goes to anything that's on that list that we put that's subject to, let's say, finalizing the clearing rules or the CEF rules or the business conduct rules, et cetera, necessarily has to wait until we finalize that rule. Is that right?
That's correct. There's nothing in any of those proposals.
So basically, there's no December 31st deadline on that necessarily. What we've put the December 31st on is this exemptive relief on things that might be self-executing or self-effective in the statute.
That's correct.
Okay. My other question is without speaking for the SEC, but can you just share with the public and us your coordination with the SEC on this?
Yeah, we've had, as we have, and the CFTC staff has on many of the Dodd-Frank rulemakings, consulted and coordinated with our colleagues on the staff of the SEC. We've been discussing this issue with them for quite some time and discussing our proposed approach with them, and they've shared their proposed approach with ours at the staff level. I would also add, also consistent with the direction in the Dodd-Frank that Congress provided for consultation and coordination with other prudential regulators, we have also reached out to the other prudential regulators and done consultation and coordination with them as well.
And I understand you actually did a briefing for the FSOC deputies last week on this?
That's correct. We briefed the Financial Stability Oversight Council deputies on this issue last week, and the SEC also at that time.
And then my last question is related to the no action relief. I understand it, though we have this exemptive relief in Dodd-Frank, Congress did put some limitations, even if they're modest, but there were some limitations that staff would be doing a no action letter. Would that also be posted on our website so that people could have a look at that and so forth?
We could do that. We could do that, Mr. Chairman.
I think that would be good for transparency. I think that would be very helpful. Commissioner Dunn?
Thank you, Mr. Chairman. The only question I have is the one that my colleague, Commissioner O'Malley, brought up, is when we do repeal Part 35, and we're saying in here that there's going to be a continuation of Part 35, when that final regulation comes up, would that issue be addressed at that time in that final regulation?
Presumably, yes, Commissioner, that the proposed regulation, the Commission would have several options, either not issue the final regulation because it would entail a repeal of Part 35, or alternatively, the Commission could issue the final regulation but not make effective the repeal of Part 35 for however long as the Commission determined that Part 35 should remain in effect. So The Commission retains full options to retain Part 35, however long as necessary within that rule, and even if that rule is effective.
Mr. Chairman, I was remiss in my opening statement not to recognize Commissioner Summers and her bringing to our attention the need to address this issue, and I greatly appreciate it. She brought it up 2 or 3 public meetings ago, and her staff and she have been the clarion call on getting this done. And I've been frustrated, as has other members of the Commission, on not having a list. If I know at a number of our senior staff meetings, where is the list? I want to know which ones are being effective. That, to me, is symptomatic of not having enough staff for us to be able to do the regulations on a timely basis. And I'm reminded, back when I was in the service, we had a saying, when you're up to your backside in alligators, it's hard to remember that you're there to drain the swamp. I've cleaned that up a little bit, Mr. Chairman. But these are some of the alligators that are biting our backsides here. And we have to drain the swamps. We have to make sure that we correct our financial services industry so we don't have a meltdown that we've had before. I think we're going to run into these types of issues time to time. That's why I've long advocated sunset provisions on regulations that we're proposing, that at least putting everyone on notice that we're going to review these to make sure that we don't have any unintended consequences. And, Mr. Chairman, when I went to you earlier on and said, please put in a sunset provision, that is exactly what I had in mind. I think we need to hold the Commission's feet to the fire to get these final regulations out there. I'm reminded of the no action letters that were out there for 10, 20 years that staff was no longer even aware of. And it was one of the initiatives that you put in place when you became chairman of the Clean Plate agenda, I believe you called that, where you went in and took a look at those and said, this doesn't make any sense to us. There are no action letters out there that should be revoked or at least addressed in a regulation, and I appreciate that activity going on. I think it is imperative that we have a deadline over us to work as hard as we can to get these finalized. And that, to me, would be the ultimate legal certainty that the industry is looking for.
I thank you, Commissioner Dunn, for your compliments. You better watch it. We might be calling this the Dunn sunset, but it was Commissioner Dunn who first suggested it, so I thank you. Commissioner Summers.
Thank you, Mr. Chairman. I think I'll follow up on that last subject matter that Commissioner Dunn was talking about with the sunset provision. Because we have not finalized key definitions, we're in this place. And so my understanding of a tentative schedule for us finalizing rules, we may have entity definitions at the top of our list, but product definitions, because the comment period doesn't close until mid to late July, I think it's the 22nd, July 22nd, it is calendared for a later time in the fall. I think that we could avoid having an issue with the sunset provision if there's a way for us to have both entity and product definitions finished at the top of the list. So I guess my question is that possible for us to do? Can we get with the SEC to finalize the definitions both of entities and products at the beginning of the list so that we don't run into having a final rule on the definition of swap that's not finished by December 31st and having to extend this relief?
We have been closely coordinating with the SEC on not only on the substance of rulemakings but the schedule of rulemakings, and we're working very closely with them to go to the final stage on these definitional rulemakings, because we, and both at the staff level, we all recognize that these are critical, in the critical path to getting the other regulations implemented. So we are working with them and trying to get a schedule for these.
Commissioner Summers, I've spent a fair amount of time with Chairman Shapiro, and I know that each of the commissioners do with the commissioners at the SEC as well. I've made that same point. I think that entity definition is more likely. We do have a roundtable in it's 2 days, I think, a public roundtable on that, which I think a number of commissioners, Commissioner Mayo for sure, suggested that we have. But if we can move on the entity definition, and as you say, since products closed July 22nd, we'll have to see how many hundreds of comments we have to try to move that early after, I guess it would likely be early after Labor Day, because I share that view. But it's also the SEC has a lot of other things they're working on, rating agencies and a lot of other topics, so that, is part of what the challenge for both of our commissions are. But I think we're aligned. Maybe we can get it over the line with the SEC, and it's just a lot of staff work, obviously, depending upon how many comments we get.
Well, obviously that's my preference, and I think that it could help us avoid some of the issues with this sunset provision if that were doable. With regard to the order, we state up front in the order that we are issuing this notice of proposed order and request for comment to provide greater clarity regarding the applicability of various statutory and regulatory requirements. Will market participants be able to identify which provisions of the CEA are the subject of the relief being proposed today?
I believe so. That is the intent. We've provided a list of, as the Chairman described, and we've used Category 1 provisions, which are the provisions in Dodd-Frank that require rulemaking and therefore will not be effective until those rulemakings are complete. We have provided a list of provisions for which we're not granting relief. We are providing relief for provisions in the Act which specifically reference swaps and swap entities and these definitional items, so people can look and determine whether or not there's one of those terms in referenced and therefore whether there's relief. On the repeal of the CFMA provisions that were added, the scope of the relief that we're providing is essentially the same as the scope of the relief under current law, and that's a general type of relief rather than a specific relief. So it is basically market participants who can understand what they are exempt from now will understand the scope of this proposed order exemption.
I hope that that's right. I mean, I wanted to make it clear that our intent here today is to make sure that market participants have a very clear understanding of what this relief applies to. So the goal here is to make this extremely clear.
That was certainly the intent in drafting this and in categorizing this way. People could figure out which category of regulation they're in and therefore whether relief would or would not apply. As was noted in the opening remarks, part of the purpose of the comment period to see whether we got it right. And so we're looking forward to comments. I know when we provided this to the divisions, and much of the material you see in the order is a result of the process within the agency of trying to get it right and trying to identify all the relevant provisions and ensure that we did. So we welcome the comment period for that purpose.
I have a number of additional questions, and my objective here is to not confuse everyone in the audience or people listening, but to make some of these issues much or answer questions that maybe someone would have. I'm going to start with footnote 16. And footnote 16 refers to areas where the Commission does not have authority to use 4C exemptive authority, and mentions that staff is considering issuing no action relief. And as I said in my opening statement, I actually have a preference for some other sort of relief besides relief issued by staff. So my question is, does the Commission have authority in these areas other than 4C authority, such as issuing a policy statement or Commission guidance? And then what in your opinion would provide the most clarity to market participants?
In addition to the staff no action relief, the Commission itself could also indicate a determination whether or not it would take enforcement action against for violation of these provisions. The no action relief does not necessarily have to be issued by the staff. The Commission retains the authority to do it itself. Traditionally, there are pros and cons of doing it versus a staff no action versus a Commission no action, which so there's pros and cons of doing it each way, and in different circumstances one could do one or the other.
Okay. So we're not bound to issue staff no action relief?
No, the Commission could take a similar action itself.
Okay. Within that same footnote...
Well, but I would clarify that it wouldn't. We would have to be careful not to wade into the area that is exemptive relief, because the statute says we can't give exemptive relief. So the Commission would have to be a little careful in how it would do that.
So would Commission guidance be issuing exemptive relief?
We could work on providing the options in that area to see how we could thread that needle.
Okay. On the same footnote, this is with regard to the anti-fraud and anti-manipulation provisions, including CEA Section 4B to cover swaps. And the footnote says that although these provisions, therefore, would, under the proposed relief, not apply to swaps under the Dodd-Frank Act, because that term is subject to further definition, nevertheless, they will apply to all transactions other than swaps, including but not limited to futures contracts, options on futures contracts, transactions with retail customers in foreign currency, or other commodities pursuant to CEA Section 2C2. The last part of this refers to, and transactions subject to exemptive relief pursuant to Part 2 of the proposed order. Can you explain what transactions subject to exemptive relief pursuant to Part 2 of the proposed order would cover?
This would cover basically the type of agreements, contracts, and transactions that are covered within Part 35. If an agreement or contract or transaction would fall under the current Part 35, or the scope of relief that we're providing, which does not have the same type of limitations as Part 35. In other words, they could be cleared, they could be standardized, they'd be entered into by eligible contract participants. Those agreements, contracts, or transactions, the anti-manipulation authority and anti-fraud authority would apply to those types of agreements, contracts, or transactions.
Okay. Moving on to our ability to issue grandfather relief, I think that Congress gave us the ability to provide grandfather relief to both 2H and 5D markets. And I've talked about this before, about whether or not grandfather relief provides any other relief that we are not providing today. And I just would like to hear your comments on whether the relief issued under this proposed order and the proposed grandfather relief for 2H and 2D would be the same, or are there any differences there?
We believe that for the time, apart from the time period difference in terms of the December 31st date, or the length of the period, that within the time period covered, that this order provides the same relief from applications of the Commodity Exchange Act that the grandfather relief would provide.
There's also a footnote that says that nothing in this proposed order is intended to impact the availability of grandfather relief. So I'm just wondering, are we contemplating that after we issue this order, that at some point somebody could be granted grandfather relief?
This footnote was intended that if you have grandfather relief already, this does not displace what you already have. So to the extent that we've already granted grandfather relief for certain of the 2H3 through 5 transactions and the 5D transactions, that relief would continue in effect.
So I guess that's what I'm confused about. I didn't know that we had already granted grandfather relief.
We had granted grandfather relief for yes, we granted exemptive relief for 2 classes of transactions, those the exempt commercial markets and the exempt boards of trade back in the fall. The 2H3 through 5 provisions and the 5D provisions. We do have grandfather relief in place for those. At the same time, the Commission determined that it would, at that time, it would not issue grandfather relief for the 2H1 or 2 transactions, which are the ones that are not taking place on exempt commercial markets.
So anyone that sent in a petition under our request for those petitions, they've been issued grandfather relief? I was under the impression that we had received thousands.
Some have and some haven't. Certain we granted grandfather relief for certain of the petitioners, but not others. And to the extent that we granted relief, it wasn't limited to the actual people who petitioned.
Carlene, why don't you just take the mic?
Let me just clarify the General Counsel's statement on the nature of the grandfather relief that was issued back in September. The grandfather relief that we issued in September extended to the facilities themselves, so that would be the ECMs and EBOTs, and not necessarily the transactions of the market participants trading thereon.
I thought that the petition said that you had to have a pending DCM or CEF application in order to be granted relief.
The grandfather order that we issued back in September lists a number of conditions that must be continually met by the ECMs and EBOTs to be able to rely on the grandfather relief, and the condition that you just cited is one of them.
So do people have CEF applications pending?
I think David could help.
David, why don't you
very
take the night?
confused.
David Van Wagner, who's the Chief Counsel of the Division of Market Oversight.
Sorry, no. Yeah, one of the conditions was that when the CEF rules or the DCM rules, come into place, that within 60 days of the effective date of the CEF or the DCM rules, that it have to have an application here, and it would have to remain pending. So until such time as that condition is possible, I would say that they can't fail that condition of the relief. So
As long as they're meeting all the other conditions,
right,
then we granted them the relief.
At this point, really the only thing that they could have done for 2H3 markets is gotten their petition here in time, which was back in the fall, and then actually EBOTs can continue to file a relief petition up until July 16th. That's just a quirk of Dodd-Frank. So
Okay,
technically they still can. So the ECMs that have relief are known at this point. The EBOTs who have relief will not be known until, in totality, until July 16th.
And there may be entities that have pending applications that are operating, say, under 5D, that now have until July 16th to get a petition in.
Correct.
Okay.
And just one other clarification, just to throw in, when you refer to the thousands of petitions, most of them I would characterize as the vast majority were requests for relief from 2H1, and the commission, as part of their orders back in the fall, indicated there are the view that we would not be granting relief. However, at that time, we might, closer to the date of Dodd-Frank's implementation, i.e. July 16th, 2011, take up this issue, and I think that's what's being done here. And so, again, if this is adopted, all those 2H1 parties will get swept up into the order that's pending before you now.
And do you believe that this is comparable to what they would have been given in grandfather relief? This order?
Yes. I mean, the only real discrepancy is that if they had been granted relief, they would have gotten it through July of 2012, so the timing is not, in sync. But obviously enough, December 30th comes around and we decide to extend. So.
Thank you.
Sure.
I have a number of questions with regard to the different types of categories that we're extending this relief to and that have pending rulemakings. So, for example, if the DCM core principles are effective before the rules and guidance are finalized, how is a DCM supposed to comply? If you look at Core Principle 9, how can a DCM comply with Core Principle 9 as of July 16th, given that the language was changed in Dodd-Frank? So that's one of the examples.
On the DCM, the core principles could come into effect, and as the statute provides, the DCMs would have substantial discretion in determining how to comply with those core principles in the absence of or prior to commission providing further guidance or interpretation. So they would have substantial discretion to determine how to comply with those requirements.
And does that mean that they should plan to comply with pre-Dodd-Frank core principles until things like the Chief Compliance Officer rules are finished?
I believe the Chief Compliance Officer is a specific. There's no Chief Compliance Officer.
There's a Chief Compliance Officer requirement for DCOs. So if you look at the structure of the statute itself lays out certain responsibilities for the Chief Compliance Officer, and these don't require rulemaking. And then there's one provision which goes to the annual reports, and there the Commission has proposed rulemaking as to the contents of the annual report. So it's staff's view that if you look at the duties, they're fairly clear as to what the Chief Compliance Officer has to do. So that's why this particular provision is in Category 4, if you look at the sheet that OGC has provided, which is that they come into effect. Because it was staff's view that a rulemaking was not required, nor was it dependent on any other proposed rulemaking, in order for a DCO to make sure that somebody was serving as Chief Compliance Officer.
How should a DCO comply with that provision then? A DCO should know that they have to have a Chief Compliance Officer in place by July 16th, even though we haven't laid out the duties yet?
Actually, I would say that the duties are prescribed, and so I would argue that the DCO should designate an individual as a Chief Compliance Officer. The only thing that's not been finalized are the details of the annual report that the Chief Compliance Officer has to provide. But as far as everything else, I'll just read you the duties. Report directly to the board as senior officer, review the compliance of the DCO with respect to core principles described in subsection C2, be responsible for administering each policy and procedure that is required to be established pursuant to the sections. I would argue these don't require rulemaking. Now, of course, once the Commission finalizes its proposed rules for implementing the core principles, then the Chief Compliance Officer will be responsible for making sure that the DCO complies with these core principles, with the regulations.
Thank you. And one last question on private rights of action. Do you believe that the proposed relief today provides protection from any private right of action claim based on the failure to comply with the CEA as amended by Dodd-Frank?
Yes, we do. We believe it provides that protection.
Thank you.
Thank you, Commissioner Summers. Commissioner O'Malley.
Thank you. Kind of following on that line of questioning by Commissioner Summers, General Counsel Berkovitz, what counsel would you give a DCM transacting swaps going forward? What set of rules are going to apply between now and December 31st? We've got the core principles that apply, but if they transact swaps, what set of rules should they use?
Actually, Commissioner O'Malley, that's a very good question. The DCM transacting swaps question is one we have actually been discussing at the staff level as recently as very late last night, and I think that's one we're looking for some comment on during the comment period and further discussion here as to exactly how we would, whether we would grant full exemptive relief for a DCM that wants to do swaps. So we look forward for some input and further thought on that before we finalize the order.
Thank you. Let me ask you another question regarding large trader reporting and other reporting and record-keeping requirements apply during the term. How will all of these requirements apply during the period of exemptive relief? The proposed order does not appear to set forth clear guidelines, whereas I understand the SEC may be considering this issue in far greater depth. Do you have a thought on this?
Excuse me, on the specific reporting? And
large trader reporting, for example?
Right. Large trader reporting, should the Commission issue a final rule, we would anticipate under this approach in the proposed order that there would be further guidance in that particular rule. It's exactly what the implementation schedule would be for that. This approach contemplates that as the Commission issues regulations to implement Dodd-Frank, either through the definitions themselves, the definitional rulemakings, or the substantive requirements, that implementation will be addressed in each of those instances. And whether one comes before the other, we don't know at this point. But when we get to the point where we're issuing rules, we're going to either have a definitional rule first to be followed by implementation, or an implementation rule followed by a definition. So the phase-in will have to be addressed in either of those instances, whatever order we're going. And so the same is true with large trader reporting. We'll have to provide greater clarity in the rulemaking itself.
Thank you. Can you, in reflecting on the proposed rule-making here, the staff recommendation, should the market have any expectation that the Commission will renew this exemptive authority beyond December 31st if the relevant rules are not in place?
I can say as the intention as the CFTC staff, we believe that the Commission indicated this intent in the when it addressed the grandfather issues initially, as David was talking about in an initial order on the grandfather, said the Commission statement of intent to ensure a smooth transition. If the Commission issues this proposed order and final order, there would be similar statements of intent. The Commissioners have expressed it. I certainly take that intent very, very seriously, and the staff intends it as well. So I think the intent is pretty clear that the Commission intends to provide this smooth transition, and those statements of intent are also reflected in the roundtable and the phasing in of implementation. So I think this is a theme that is pretty consistent in a number of orders, roundtables, and forums that the Commission has issued. So I do think that there is that clear statement.
But it's not explicitly stated in the proposed rulemaking. What we're working on. I mean, they just have to, based on our conversations, et cetera, they're just going to have to hope that we have an extension.
Well, in terms of drafting the proposed order, it would. We didn't think we could draft a proposed order that would bind a future commission that might be in a future order that time. Ultimately, the future commission would make the determination. So we couldn't go further than we went.
Well, I appreciate that. And before I go to the amendment, I do want to mention or respond to Commissioner Dunn, and we will now forever know it as the Dunset provision. And I will no longer refer to it as an arbitrary date. It will be the Dunset provision. And I appreciate the fact that, as he stated, he wants to hold our feet to the fire. And one would argue that that's what the statute intended us to do. And despite our best efforts and the staff absolutely working as hard as they possibly can, and the attentiveness of the commission as well, and the hard-charging nature of the chairman, we still were not able to meet the statutory deadlines. And as the chairman said, this is not about delay. And I think if we were going to hold our feet to the fire, the best way to do that would be to put forward an implementation plan that we can march in order by each rule and have the public do that, understand where we are and what's coming up next. So I would, again, make that plea. But is it now appropriate that I move to amend the staff recommendation with the following amendment?
Sure, Commissioner.
Will I make that motion?
Second.
The amendment, as I understand it, is to drop the sunset or the Dunset.
The Dunset.
And so then it is, I'm told it's debatable, and then we can vote on. I'm not going to support the amendment as offered by Commissioner Malia, but I do appreciate all of the work that you've put into all of what we're doing, but even this amendment. I think it is important, as Commissioner Dunn said, that we move forward, we give the markets this relief, but that we take up whatever further relief might be appropriate at the time, knowing what we know then. As Commissioner Summers said, that may well be a little bit more time than we have this time. She suggested, 7 or 8 weeks before, 8 weeks before, rather than in this case, it's about 5 weeks before. But I think that we'll know a lot more then, and I do think that the American public is still very much vulnerable. The crisis in 2008 was very real. The regulatory system failed. Congress reacted. The President reacted. That this swaps marketplace be brought with transparency, openness, competitiveness, and we lower risk. And I think that our staff is doing an excellent job, and we'll start to take up some final rules this summer and into the fall. I agree with Commissioner Summers. These definition rules are very important. And then we could see where we are come, probably early November. And it would be my hope that we've gotten most of these final rules done, or maybe all of them. And if not, we can then see and tailor to where we are. So I will not be supporting your amendment.
Mr. Chairman, I appreciate that and your willingness to entertain this, and the Commission's willingness to entertain this amendment. You make mention of the fact that we will have our rules completed, but what matters is the transition when they completing the rules and implementing the rules, as you have noted on numerous occasions, is going to be a different date, and there's going to be phasing, and I support that. And obviously we need to understand getting them done and when they're going to implement might be a bit of a delta, and we need to understand how that transition will occur.
And I think that's a very good point, and I think that, in fact, the market will benefit that we phase, that will lower risk to the American public and lower cost by phasing the implementation, or technically it's phasing the effective dates. I would note, again, this exemptive relief is only on those things that are self-executing. If it's dependent upon a clearing rule or business conduct rule or CEF rule, it's it doesn't go effective until the earliest of 60 days after the final rule, and in many instances will delay that 60 days.
Well, I advocate that we put all those rules under the same condition. Let me ask you: do you think there's any chance that the Commission would not renew the exemptive relief prior to rule implementation?
I think that it's best to take that up at that time and just see what the circumstances are. I agree with General Counsel Berkovitz that it's terms of the intent, it's the chairman's intent, that this is a smooth transition. These are very significant changes that in market structure that swaps will be regulated after having been unregulated for 30 years. And to get this smooth, to phase it, I've been a long advocate and public advocate for. But I think it's best to take it up, and as Commissioner Dunn says, to keep us focused that the American public's still vulnerable until we get this stuff done. But Commissioner Dunn.
Thank you, Mr. Chairman. I would like to see this Dunn amendment become a done deal. And again, the two reasons that I've given here is to hold our feet to the fire. And I am concerned that it's taken us this long to recognize that this is a problem, and we should have addressed it much earlier, as Commissioner Summers has advocated. By having a sunset on there, it doesn't allow the Commission to say, oh, well, that's covered. It gives a certain amount of urgency to get these things completed. Mr. Chairman, I tend to agree with Commissioner O'Malley. Yes, we'd like to see what's coming up on the plate, what's next up. I think everyone would like to see that, but the fact that there is going to be a phase-in provision on these final rules is also something that ought to be a certain amount of relief to the industry as a whole out there. Legal certainty, I can understand people wanting to know legal certainty, and for all of those folks that have questions of is this product in or out, am I as an entity in or out, it would be my hope, Mr. Chairman, that the Commission and the staff commit to responding to those types of inquiry within a reasonable amount of time so that people understand where they are in this. The second reason that I have given is that hopefully there will be a new commissioner sitting here soon, and I think it's incumbent upon me to allow that individual to have some say in the policy as we go forward on this. And for those reasons, I'm very adamant that we have the sunset provision in there. I go back to no action letters that sat on the books for decades that in some instances staff didn't even know they had been issued, but the individual that got that was aware of it. So I feel it is a way to maintain some discipline.
Commissioner.
Just have a couple of comments. I think I have no objection to this kind of exemptive relief having a sunset. I think the more appropriate sunset would be upon the effective date of the new rules we're putting in place. My worry, my fear, is that this is a very serious issue, and the market uncertainty that we could create by not extending this relief could be worse than, what I've been talking about for the last couple of months. The fact of the matter is we have on a tentative calendar the product definition scheduled to issue for November or December, which means we already know now that we probably won't have that done in time for December 31st. So unless we make some sort of commitment right now to make sure that the definitions are done first, we're going to end up in the same place.
I don't think Commissioner Chilton is tied in by phone, is he? No, he didn't. Oh, okay. I think with that, I'm supposed to just, do I have to call a vote on the amendment, roll call, or what do we do, Mr. Staywick?
You may.
Fine.
I'm happy to call a roll. This question again is on the O'Malley amendment. Commissioner O'Malley.
Aye.
Commissioner O'Malley, aye. Commissioner Chilton.
I have a document somewhere. What is it? I just want to make sure. I think I know what it is.
It's right here.
Opposing the amendment to extend or eliminate the expiration date included. So I think that's no by proxy.
Commissioner Chilton, no. Commissioner Summers.
Yes.
Commissioner Summers, aye. Commissioner Dunn.
No.
Commissioner Dunn, no. Mr. Chairman.
No.
Mr. Chairman, no. Mr. Chairman, on this question, the yeas are 2, the nays are 3.
The motion did not pass. Then I think we'll go, Mr. Staywick, to the order as proposed by the staff.
Commissioner O'Malley.
Aye.
Commissioner O'Malley, aye. Commissioner Chilton.
In favor of the motion to accept the staff recommendation to issue the proposed order and request for comment. So that's an aye.
Commissioner Chilton, aye. Commissioner Summers.
Aye.
Commissioner Summers, aye. Commissioner Dunn.
Aye.
Commissioner Dunn, aye. Mr. Chairman.
Aye.
Mr. Chairman, aye. Mr. Chairman, on this question, the yeas are 5, the nays are 0.
Thank you, Mr. Staywick. Thank you to my commissioners. With it being unanimous, we will seek to send it to the Federal Register post haste. I thank our friends at the Federal Register. Hopefully it will get in the next 2 to 3 days. But there's a couple more things I have to do on dates. But
Just
General Counsel
permission to make a few technical corrections. We will not interfere with the expeditious getting this to the Federal Register. It will improve the getting this to the Federal Register.
I ask unanimous consent that General Counsel Berkovitz able to make technical corrections. Not hearing opposition, so allowed and moved.
Mr. Chairman, just a point of clarification then. I'm assuming that final vote will be by seriatim then.
It will either be by seriatim or we need to have a public meeting, but seriatim is all right with me. I mean, just to get it out there. But I don't know if we have something scheduled before July 16th. I'm about to turn to that. The next item for today is to vote to authorize publishing a Sunshine Act notice for some meetings. I see here that we have meetings July 7th, July 19th, August 4th, September 8th, and September 22nd. So I guess, Commissioner Dunn, you're correct unless people want to get, I'm ready to get together before the 16th if you want to do that publicly. So if you want to do something on the 14th or something like that, we could do that as well.
So it won't be ready for the July 7th meeting?
Will it be ready for the July 7th meeting, Dan?
Well, we'll have to see what the comments and if we have a 14-day comment period and we get it, that puts us to about June 30th. So I think it'd be tough to. We'll do the best we can, but that's also the July 4th weekend. So to 1 week with the July 4th.
So I think it would be best if we had it the July 7th. But are you saying that should we sneak a date in here, call it July 13th or 14th?
We want to get it right. So we
doing it with
few
apologies
days would
at
help.
least.
I would prefer to do it by seriatim if it's not ready by the 7th.
I think the seriatim would be fine.
I go with the will of the commission. But all meetings are scheduled to begin at 9:30 and will take place in this room. Agendas, of course, will be published 7 days in advance. Sorry to do this to your staff, Dan, but I'm hopeful that we could do it to the July 7th. I think that would be helpful. And it also gives the market a little bit more preparedness for the 16th, if possible.
And it will depend on the comments. I think if we don't have substantial revisions or the comments can be incorporated, we can do it sooner.
Okay. And then
we'll
I guess I'm making a motion on the Sunshine Act. So do I hear a second?
Second.
do I need to do it through Mr. Staywick, or do I just do it? All right, fine.
Yes. Commissioner O'Malley?
Aye.
Commissioner O'Malley, aye. Commissioner Chilton?
It looks like it's in favor of the motion to schedule the meetings.
Commissioner Chilton, aye. Commissioner Summers?
Aye.
Commissioner Summers, aye. Commissioner Dunn?
Aye.
Commissioner Dunn, aye. Mr. Chairman?
Aye.
Mr. Chairman, aye. Mr. Chairman, on this question, the yeas are 5, the nays are 0.
It being unanimous, we'll send that on. The CFTC has substantially completed its rulemaking around these 30 topics, and our next meeting will be on July 7th, and the subjects of that meeting will be posted at that time. Some of the meetings that we're thinking, some of the topics we are thinking about taking up, and I'm doing this off script, but just because we've distributed it along here, is in these July and early August meeting, without trying to be specific on the dates, and staff will probably shoot me for doing this, but we're looking at anti-manipulation and trying to finalize the anti-manipulation rules subject to where the commissioners are. The large trader reporting, there's a number of process rules related to Part 40, but also with regard to clearing determinations. There's a mandatory clearing, but there's a process rule with regard to that. Agricultural commodities definition seems about ready to be teed up, and there's some rules about credit ratings possible, but I don't know if that will be teed up. And then there's some privacy notice provisions in FCRA and GLB, Graham-Leach-Bliley, and so forth. I'm probably missing a few things for these July meetings. We are working, and there's a significant staff dedicated to completing the summary and getting recommendations up to the commissioners on position limits. There are many rules that were reopened through June 3rd. We are now at about a little over 20,000 public comments in the comment files. About 12,000 are related to position limits, but the other 8,000 grew significantly when we reopened for 30 days. So in some cases, the teams only got 4 or 5 more comments and are pretty ready to give us summaries and give us feedback. In some instances, they got 50 or 100 comments or even more, and so it will take a little bit longer. But what we're looking to do is get the comment summaries and staff recommendations, percolating up a lot of these in June and July. But to the extent that they do that, I think that some of those meetings will have to be calendared for the September period to finalize clearing rules, finalize CEF rules, and business conduct rules. But it's still dependent on how the comment summaries, and most importantly, your advice back to staff, each of you, as you start to look at the comments yourself, that we can bring these together. The entity definition and the product definition, I share Commissioner Summers' views. We've had very good dialogue with the SEC on both. We're going to have a joint roundtable on the entity definition in a couple days. But again, depending upon some of these newer comments, just to see how that able to take up, I would hope, shortly after Labor Day. But we're human, as I continue to say. Things can slip. These are important matters, and we want to get it right and balanced and so forth. So that gives, I'm just trying to give a little bit of the, Mr. Berkovitz, anything else? Any other issues? With that, can I just entertain a motion? No, you don't have to do anything else right now. Entertain a motion to adjourn the meeting.
So moved.
Second.
All in favor?
Aye.
Any opposed? Thank you. The meeting was adjourned. We'll see you on July 7th, I think.